Buenos días. Muy buenos días a todos. Good morning to everyone here at the auditorium and also all those that are joining us through the internet. Our website, encuentrodeterritorios.com, our Facebook page, and also our Twitter page. Welcome to the first meeting of the United States Overseas Territories. This is our primer encuentro de los territorios de ultramar de Estados Unidos. Here at the Aide Piñero Book Auditorium of our host institution, the Jesus T. Pinheiro Library and Social Research Center, in Spanish, Biblioteca y Centro de Investigación Social Jesús T. Piñero. In short, the Piñero Library or Piñero Center, Biblioteca Piñero o Centro Piñero. The institution is part of our host university, Ana G. Mendez University, Carolina campus. I'm Dr. Raymond Laureano. I'm a collaborator with the Piñero Center. We are working towards organizing here an archive with a focus on Puerto Rico and the Caribbean's international relations and economic development. And we have as a starting point a document collection of Antonio Tito Colorado, Puerto Rico's former Secretary of State and U.S. Congressman for Puerto Rico. I will be your host today, and we will be navigating together through an exciting and informative full-day experience. The morning session will start with our guest speaker, Mr. Jeff Farrow. We will follow up with a discussion table on the history and development of the territories in terms of their relationship with the United States. Later on, we will begin the discussion forum with the delegates to the U.S. Congress from Guam and Puerto Rico. In the course of that discussion, some former delegates of both territories will join the panel too. Later at noon at 12:30, we will have a lunch break, and at 12:30 as well, the legal research firm Microjuries, one of our sponsors, main sponsors, will be hosting a reaction table from the Jesus T. Piñero Gallery, which is a room close to one of the building entrances here at the first floor. And then panelists, moderators, guest speakers, special guests, and sponsors, which have red and blue IDs, will be getting together for lunch at the Ishka restaurant. That's the Jose Tony Santana International School of Hospitality and Culinary Arts. Members of our staff will be escorting you to the Ishka. For the rest of our audience, we have various options for lunch in campus. You will find that information in the registry area along with a map of the campus. In the afternoon, then we will be starting at around 2 o'clock with guest speaker, Chief Judge of the United States District Court in Puerto Rico, Gustavo Gelpi, with a conference titled The Federal Court and the Role in the Constitutional Relationship between Puerto Rico and the United States. After that, we will have our last discussion panel, which is the constitutional and jurisprudential development of the territories. After that event, at 4:30, the firm Microjuries again will be hosting a reaction panel from the Piñero Gallery right here in the first floor. You are all special guests indeed, but allow me to introduce you to some individuals that have lent their support to this event by being here among us. Please, let's welcome Honorable Jennifer Gonzalez, Resident Commissioner for Puerto Rico. Honorable Michael San Nicolas, Delegate in Congress for Guam. Also have lent their support to this event by being here among us. Please, let's welcome Honorable Jennifer Gonzalez, Resident Commissioner for Puerto Rico. Honorable Michael San Nicolas, Delegate in Congress for Guam. Also have lent their support to this event by being here among us. Please, let's welcome Honorable Jennifer Gonzalez, Resident Commissioner for Puerto Rico. Honorable Michael San Nicolas, Delegate in Congress for Guam, also have lent their support to this event by being here among us. Please, let's welcome Honorable Jennifer Gonzalez, Resident Commissioner for Puerto Rico. Honorable Michael San Nicolas, Delegate in Congress for Guam, also have lent their support to this event We are just testing the sound system. Please, let's welcome Honorable Jennifer Gonzalez, resident. It's working great. We continue welcoming our guest, Antonio Joto Colorado, former resident commissioner for Puerto Rico and former Secretary of State. Kenneth McClintock, former Secretary of State for Puerto Rico and former president of the Puerto Rico Senate. Dr. Robert Underwood, former delegate in Congress for Guam and also former president of the University of Guam. Mr. Jeff Farrow, former co-chair in the President's Working Group on Puerto Rico under President William Clinton administration. Dr. Carlyle Corbin, former Minister of State for External Affairs for the U.S. Virgin Islands. Mari Carmen Aponte, former American ambassador to El Salvador and also former Assistant Secretary of State for Western Hemisphere Affairs. Engineer Margarita Varela-Rosa, representative for Congressman Raúl Grijalva. Honorable Carlos Delgado Altieri, Mayor of San Juan, Puerto Rico. Dr. Mildred Huertas, Isabela, I'm sorry. Dr. Mildred Huertas, our host chancellor here at the Ana G. Mendez University Carolina campus, our host vice chancellor, Dr. Felix Huertas, from the Ana G. Mendez University Carolina campus. Edgardo Roman, president of the Puerto Rico Bar Association. Julio Fontanet, dean of the Inter-American School of Law. Dr. Juan Fernandez Velázquez, former chancellor of the University of Puerto Rico. Janifla Cascad, director or former director of European Affairs and Cooperation in Martinique and Guyana, and French Guiana, and faculty members of Ana G. Mendez University. So welcome all to this event that promises to be very exciting and informative. Let us now start the welcome messages with Attorney Yvonne Lazada, the organizer of this event. She is the executive director of the Jesus T. Pinero Library and Social Research Center.
Welcome, everyone, and I need to apologize for the people outside from Puerto Rico because we are running on Puerto Rican time. Así que bienvenidos a todos, and I'm going to be primer gobernador puertorriqueño y donde guardamos el archivo histórico del gobernador. Los que, como les dije, no han visitado, este proyecto surge como una iniciativa de la familia de Piñero, junto con la Universidad Ana G. Méndez. Don Jesús T. Piñero y Ana G. Méndez eran muy amigos en los años 40 y un poco el proyecto de la universidad está vinculado a los proyectos de desarrollo económico de esa época, específicamente en lo que era manos a la obra. Uno de los principales objetivos de este proyecto, obviamente, es dar a conocer la figura de don Jesús T. Piñero, preservar el archivo histórico. Para eso tenemos varios proyectos de conferencias y de exposiciones rodantes. Besides getting to know the figure of Jesus T. Piñero in the island as a politician, he was also a resident commissioner for Puerto Rico in Congress and the first, as I said, first native governor. We have other projects here through the Social Research Center, and we try to develop forums and activities around those lines of research. Lo que estamos tratando de hacer es adaptar y desarrollar foros y conversatorios alrededor de lo que son las líneas de investigación de la biblioteca, del Centro de Investigación de la Biblioteca Jesús T. Piñero, con otros centros educativos, como lo ha sido el Centro de Estudios Avanzados de Puerto Rico y el Caribe, Cuando yo inicio hace poco más de un año y pico, a dirigir este proyecto, habían dos proyectos principales que me llamaban mucho la atención. Uno era un proyecto de investigación sobre los gobernadores designados desde el 1898 hasta el 1946, que fue el último designado don Jesús, obviamente cubriendo los primeros 4 militares. Y el segundo proyecto que me llamó mucho la atención tenía que ver con investigación de territorios. Así que se me ocurre y pensé cómo era posible, primero, qué poco sabemos los puertorriqueños con relación a los territorios ultramarinos de los Estados Unidos, muy poco. Puerto Ricans, as our guests will maybe find out, know hardly anything about the territories. If we go out in the street and ask any Puerto Rican to mention the other 4 territories, or let's say 5, because they might think, are we a territory? They won't be able to list the territories. Y es peor que eso. Si vamos a la legislatura, y entre los 78 legisladores que tenemos, le preguntamos a cualquiera que encontremos en un pasillo cuáles son los 5 territorios de los Estados Unidos, se van a quedar perdidos. Es terrible. ¿Cómo es que en 120 años, how is it that in 120 years, we haven't been able to establish a constant communication, a path of communication with Guam, with the academics of Guam, to talk about the differences, the similarities we might have in the relationship we have with the United States and with the history of the United States? Es increíble que hayan tenido que pasar 120 años y no se haya dado ese esfuerzo de comunicarnos, no tan solo con Guam, con Islas Vírgenes, que sí es muy familiar para nosotros en términos turísticos, pero es muy poco lo que conocemos de sus políticos, de su dinámica política y de gobierno y de lo que es la dinámica de ellos en su relación con los Estados Unidos, y están aquí al lado. Y no me hace ningún sentido, y por eso es que decidimos iniciar este proyecto con este evento, que no va a acabar aquí. Abrir una ventana de comunicación con los otros territorios para ver de qué manera podemos, como un proyecto siguiente, establecer un comité interterritorial académico que pueda mantener esa conversación de diferentes universidades entre Islas Vírgenes, Puerto Rico, Guam, Samoa Americana e Islas Marianas del Norte, para intercambiar impresiones, noticias, columnas, investigaciones y desarrollar y coordinar eventos juntos. Ciertamente sí hay diferencias, pero es tan difícil tratar de definir lo que debe ser el futuro o el camino que cualquiera de los territorios vaya a encaminar si no entendemos nuestra historia, y ciertamente parte de nuestra historia es la historia de los territorios, que desconocemos totalmente. Yo agradezco nuevamente el interés. Tengo que agradecer particularmente a unas personas que me han apoyado muchísimo, al licenciado Antonio J. Colorado Tito, que fue quien me ayudó a arrancar y que me paseó por el Congreso, ¿no? Y me ayudó a abrir las puertas y a reunirnos con el congresista Grijalva, con la comisionada residente Jennifer González, para dar inicio a este proyecto. Ciertamente sin él no hubiese sido posible, pero tengo que agradecer enormemente también a Kenneth McClintock, que me ayudó en la senda, en el camino, y aterrizar este proyecto. Y Kenneth, de verdad que te lo agradezco mucho, eternamente agradecida, ¿no? Y que me mantuvo un poco enfocada, de no te preocupes, vamos a hacer esto y los cambios, y estaba siempre ahí al otro lado del teléfono. Por supuesto, la rectora del recinto de Carolina, la doctora Miltres Huertas, el vicerrector, que lleva muy poco tiempo con nosotros, pero que nos ha apoyado muchísimo, a los delegados. I need to thank Robert Underwood and the delegate of Guam, Michael St. Nicholas, for their enthusiasm in this event. From the first time I reached Nick St. Nicholas' office and I reached Underwood, they accepted to come. They were so eager to come and interested. And it's great. I hope it's not just the first time that you come and that we can keep on working on other projects with you. But thank you very much to you both and Guam. I hope this, in future events, we might have more participation of American Samoa and Northern Mariana Islands. I was really very interested in listening to American Samoa with their citizen case. That was very interesting. Como ustedes saben, hay un caso reciente, no todos saben, sobre la ciudadanía de los samoanos. Los samoanos era el único territorio donde sus ciudadanos no eran ciudadanos, lo que tenían eran nacionales de los Estados Unidos, lo que se podría considerar una categoría inferior. Y en un caso reciente en el circuito de apelaciones, creo que es en Utah, que le corresponde a Samoa Americana, se decide que aplicaba la ciudadanía americana a los samoanos. Irónicamente, las expresiones de la congresista samoana es en contra de que se le otorgue la ciudadanía a los samoanos, y yo quería escuchar, yo quiero saber de primera mano por qué esa posición que para nosotros puede ser un poco extraña. De todas maneras, gracias. Hay unos invitados que se mencionaron que van a llegar más tarde, en hora puertorriqueña, como les dije, incluyendo la comisionada residente, y el secretario de Estado, que confirmó que iba a llegar en algún momento durante la mañana. Así que gracias nuevamente a todos. Recuerden que vamos a estar transmitiendo por internet, íntegro en español, en inglés por la mañana, en encuentrodeterritorios.com. A través de esa misma página van a poder someter preguntas del público. Y por la tarde vamos a estar transmitiendo en español, pero con traducción simultánea también al inglés. Así, gracias a todos, bienvenidos y espero que disfruten en la mañana.
Thank you, Yvonne, for your monumental effort to put together this event. I know that it was quite a challenging task, and you carried through with the event, definitely. Before going on, I want to note the presence of Antonio Faz Alzamora. He's the longest-serving legislator ever, over 40 years. He was the 12th president of the Senate. I also want to mention that last night I was promoting the event through the social networks, and many colleagues from different places in the Caribbean, from Cuba to Trinidad and Tobago, Martinique, Guadeloupe in the US, Brazil, and France, they were very excited about the event because they think it is a very timely topic, and they were opening the possibilities to have a comparative perspective in later events to compare the US territories versus the European Union and British territories in the Caribbean and beyond that. Now, we continue the welcome messages with attorney Antonio Colorado in representation of the board of the Pinero Library. Tito.
Good morning to all. It's a real pleasure to be here with you in this very special activity on something that I believe is so important for Puerto Rico and for all of the territories which are part of the United States. Just at this time, I just want to make sure that you feel not only that you are, but you feel welcome to Puerto Rico. We will be here. We want to hear from you, and we want to discuss and sort of make an agenda for the future. I think we've been, we're far away, except for the Virgin Islands, but we're very close in the issues that we have to deal with. So again, welcome to Puerto Rico. Welcome to the University Ana Geméndez. And it really is a pleasure to see you all here. Thank you very much.
Well, now we have Dr. Mildred Huertas. She's the chancellor of the university, of the campus, our host campus. So she will be directing some words to you.
Good morning, ladies and gentlemen. Besides receiving you in my campus as chancellor, I have a message from our president that I should read, so this is for you. Buenos días a todos. Welcome to everyone. Good morning. Me uno al saludo de nuestro moderador y deseo excusar a nuestro presidente José F. Méndez, quien no pudo acompañarnos en la mañana de hoy. Bienvenidos a nuestra universidad, un espacio que siempre está abierto para la discusión de temas que trascienden el salón de clase y que ayudan a mejorar la vida de nuestra gente y las causas que nos adelantan como país. A través de los pasados 70 años, la Universidad Ana Geméndez ha estado presente en el desarrollo de Puerto Rico porque su fundadora, doña Ana Geméndez, fue fiel creyente de que la educación transforma los pueblos, brinda la oportunidad para pensar libremente y ayuda a crear espacios de discusión serios y de altura. Este primer encuentro de territorios ultramarinos de los Estados Unidos es un ejemplo de cómo la universidad se inserta en la discusión de diferentes asuntos públicos que nos afectan. Gracias a nuestros distinguidos invitados por llegar a la Biblioteca Jesús de Piñero y compartir sus experiencias acerca del tema de discusión desde la perspectiva del ámbito gubernamental, del derecho y la academia. I want first to offer our distinguished guests a warm welcome to Universidad Ana Geméndez Carolina Campus for the inaugural Forum of the United States Territories. We are very pleased and proud to host such an impressive panel of speakers, but so more. We are honored by your commitment to Puerto Rico and look forward to sharing in your thoughts and strategies. Estoy convencida que la jornada de hoy servirá de estímulo para continuar discutiendo el tema de nuestro estatus. Más que verlo como un asunto político, es un asunto social que toca directamente a todos los sectores de Puerto Rico. Nuestro país tiene un gran potencial y la Universidad Ana Geméndez siempre estará presente en cualquier iniciativa que ayude en su desarrollo. Siéntanse como en su casa. Gracias a todos por estar aquí y muy buenos días.
Thanks to the Chancellor. Now we move on with the program by having our first guest speaker. He's Jeff Farrow. He was born in St. Thomas, and he is a nationally known leader on the U.S. territories and the nations freely associated with the United States. He was a senior staffer on the insular areas in the White House and the U.S. House of Representatives for more than 2 decades. He is staffer in the negotiation and approval of the U.S. compacts or agreements with all 3 freely associated states, and lead advisor and representative of one of them, Palau, in the renegotiation of its agreement, its compact. Please welcome Jeff Farrow.
We need that microphone? No. Okay. Excuse me. Good morning. I'm very pleased to be here. Pleased because of the topic and the discussion that we're going to have. Pleased to see the development of Ana Mendez since I was last here. Pleased because the university honored my wife with its President's Medal. She's of Puerto Rican descent and a national Hispanic leader in Hispanic organizations. I hope that the most useful contribution I can make to today's discussions is to start them off by stating some truths about the status of the territories, U.S. policies, and then a few ideas regarding status. I don't think anyone will like all of what I say. I won't like it. But these are facts that I've come to accept, having worked for and with the federal government on these issues since I became a congressional staffer in 1973. The U.S. has had a policy regarding its non-state territory, which was considered to be a part of the U.S. even before it adopted the Constitution. The Northwest Ordinance under the Articles of Confederation provided that territories would become states when they had enough people. The Constitution simply says that Congress will make all of the rules for the territories and other property of the United States. But one of the first rules adopted by the first Congress was to reenact the Northwest Ordinance. The other territory wasn't thought about at the time, but after President Jefferson decided he could purchase France's vast Louisiana territory, the U.S. felt a manifest destiny to expand to the Pacific. And after that ocean was reached, the goal became non-contiguous empire for economic and military reasons. First, there was Alaska on the continent, and then Hawaii across the ocean. The statehood process wasn't easy or quick anywhere. There were Latin Americans in Arizona and New Mexico, Asians and Pacific Islanders in Hawaii, and economic interests often opposed because of state taxes. In all, however, there were calculations of political impacts, initially on the slavery debate and then on political parties. And that brings us to the current territories. The big acquisition was through the Spanish-American War, which led to the major issue of the 1900 presidential campaign. It's an issue that only we are talking about today in the islands. The issue was formally decided in a Supreme Court cases concerning Puerto Rico. But the big factor in those cases and in the issue was a territory that has long since become a nation through a guerrilla war, the Philippines. Some in Congress were concerned that treating Puerto Rico as an ultimate state would lead to the same demand from the Philippines. In the first of the insular cases, a splintered court decided that the U.S. could acquire territory that wouldn't automatically become part of the country and instead could be a possession temporarily, but for an indefinite period, an unincorporated territory, or a colony, if you will. The ruling said that only the Constitution's fundamental rights of individuals applied in the islands. But the case concerned revenue laws, and this is the most important aspect of the issue to this very day. The Constitution requires that revenue laws be the same within the United States. Now, some Puerto Ricans logically assumed that, after the U.S. finally conceded to independence for the Philippines in 1916, it made Puerto Rican citizens to bind them to the United States. Some Puerto Ricans logically assumed that this finally meant becoming a permanent part of the United States, as it had in Alaska and Hawaii, according to the Supreme Court. But instead, the Supreme Court followed Chief Justice Taft, who had an unhappy experience as governor of the Philippines, and said Congress would have to make the intent to incorporate clear. These decisions provided the precedent for the status of all of today's territories and most of the issues that the territories face individually and collectively. The U.S. unwillingness to assure Puerto Ricans of eventual equality fueled a debate in the islands between statehood and nationhood. But the U.S. also rejected nationhood, even as it established the UN to end colonialism. President Truman later tried to get Congress to decolonize Puerto Rico with a choice among statehood and independence and essentially what we now call in English free association. But Congress only agreed to his idea of Puerto Rico drafting a constitution subject to U.S. approval. Free association is nationhood in association with another nation, in the case where one lets the other exercise aspects of its sovereignty on the condition that either can unilaterally end the association. The U.S. is now in free association with 3 other parts of the territory that the U.S. took from Japan during World War II. And I'm proud to have now represented 2 of the islands' nations in renegotiating their free association compacts with the U.S., which have had initial terms of 15 and 20 years. Because they are nations and the associations can end, the people are not U.S. citizens, although they could reside in the U.S. I diverted from Puerto Rico because its territorial constitution in 1952 named the territorial government words in Spanish that literally translate as Associated Free State. And that reflected the true desire of the territory's leaders. But because the U.S. because the U.S. wouldn't have approved saying that Puerto Rico was a freely associated state, the Constitutional Convention named the government the Commonwealth instead. Commonwealth isn't a political status. 4 states call themselves Commonwealths. The Northern Mariana Islands and other unincorporated territory does. The unincorporated territory of the Philippines was called the Commonwealth. And in Congress, Puerto Rico's leaders, in seeking the Constitution's authorization and approval, recognized that U.S. territory governing powers would remain. But after they obtained the approval, they began an effort to make it appear to Puerto Ricans that they had obtained real autonomy instead of only the ability to amend the charter of the local government consistent with unincorporated territory status. A noteworthy effort was getting the U.S. to get the UN to agree that the U.S. would no longer have to include Puerto Rico in its reporting on its non-self-governing territories. The U.S. was happy to be rid of this responsibility. When even allies, however, saw that Puerto Rico wasn't self-governing, the U.S. became more complicit in the charade. Towards the end of his life, the lead Puerto Rico architect of all of this wrote a book acknowledging the truth and questioning giving up the leverage of the U.S. having to report to the UN. He entitled it, Puerto Rico, the Trials of the Oldest Colony in the World. The hoax was very successful politically in Puerto Rico, Washington, and elsewhere. So the perpetrators sought to make it a reality with different proposals for autonomy and combinations of incompatible aspects of statehood, nationhood, and unincorporated status, all of which were rejected by the U.S. government as being incompatible with the Constitution, laws, and policies and interests of the United States. Now, to be fair, for a while, some U.S. officials actually thought that something could be worked out under the Territory Clause that would enable an arrangement that would let a territory exercise some national functions in an arrangement that couldn't be changed by mutual consent. Very limited mutual consent provisions had been included in the Northern Mariana Islands Covenant as a condition for them ceding themselves to the United States. However, the U.S. insisted also in the covenant that it be clear that the Territory Clause applied to the Northern Mariana Islands. The experiences of Puerto Rico and the Northern Marianas stimulated Guam to launch a quest for Commonwealth in the early 1980s, working with some attorneys who had worked for Commonwealthers here in Puerto Rico. And Guam's proposals went even beyond the Puerto Rican proposals. But there were a few developments in the 1980s that convinced the U.S. government that the whole concept was inadvisable and, more critically, impossible. One was a Supreme Court decision in 1985 on the limit of congressional commitments in the future. Another was the Northern Marianas' use of its covenant exemption from immigration and minimum wage laws and ability to export most products into the U.S. free of duties and quotas and label the products made in the USA. And they did this to import Chinese slave labor clothing factories onto their soil. A third development was the dissolution of the Soviet Union and the end of the Cold War. No longer would there be a USSR to use Puerto Rico against the U.S. when the U.S. complained about Soviet captive nations. The U.S. then became willing to be more forthright about Puerto Rico's unincorporated territory status. Now, it still doesn't want to have to answer to less democratic nations like Cuba and Venezuela in the UN, and it still blocks UN Decolonization Committee resolutions from the General Assembly. The U.S. follows international law when it wants, and it doesn't when it doesn't want. But there was one constructive result of the U.S. being relieved of the obligation to report on Puerto Rico to the UN. It stimulated the UN to define decolonization. At first, the definition was independence, and the Decolonization Committee was set up for that. But the U.S. refused to accept this, and then the UN agreed to options that we would call independence, free association, and statehood. There is a UN resolution that talks about other mutually agreed upon arrangements, but it doesn't meet the other of two tests of self-determination, that the status enable the people to have an equal vote for the individuals who make their laws. The dismantling of the illusion of Commonwealth really began in the public mind with a federal legislative effort to resolve Puerto Rico's status that was formally initiated by a governor of Puerto Rico who believed in Commonwealth, and in 1989, at a presidential call in an address to Congress. The governor unintentionally began the dismantling process in response to the first question in the first congressional hearing, when he said that he didn't want sovereignty. That limited what could be done. Puerto Rico would have to remain an unincorporated territory. But most of the governor's proposals really weren't to change Puerto Rico's status. What they were was to change the application of federal laws. And often when people speak of status, that's what they're really talking about. The Senate committee eviscerated almost all of the governor's proposals and essentially validated statehood and independence as options. There was a fundamental flaw with the bill, however. Puerto Rico's leaders wanted a status choice that would be binding upon the U.S. With all of the laws that would be needed to change Puerto Rico's status, and some of these laws changing each Congress, most congressional committees either found it difficult to say on a hypothetical basis of how laws would be changed under three different possible status options in the future, or they simply refused to do so. When I was drafting a different bill in the House for a multi-step process, the Speaker told me that Congress authorizing a Puerto Rican status choice would be as binding as it could be because it would impose a political and moral obligation on the U.S., and that was greater than any law because laws can always be changed. Political, moral commitments can't. There's another deficiency as well. U.S. officials acting on different hypothetical proposals for changes in law, unpressured by the mandate of the people for a specific status, don't have to be as generous. Unable to get his bill out of committee in 1990, the Senate chairman changed it to be a multi-step process in 1991. But when his committee deadlocked 10-10 with a Republican substitute that made even less of a commitment than his bill did, the governor used the opportunity to ask him and the chairman in the House, with me present, to drop the effort. By the mid-1990s, with most of its Commonwealth proposals rejected, Guam abandoned the idea and began to focus on the real decolonizing options. This debate has been primarily debated by a desire on the part of the indigenous population to have the decision made without the vote of U.S. citizens not descended from those who were there when Spain ceded Guam to the U.S., a constitutional problem. Status efforts have also floundered in my home Virgin Islands, and as have efforts in the Virgin Islands and Guam to take advantage of a U.S. invitation to draft constitutions for U.S. approval, as Puerto Rico had. The case of American Samoa is unique. It's been under the U.S. flag as long as Puerto Rico and Guam, but unlike with the Northern Marianas in 1975, the U.S. agreed to significantly unconstitutional provisions in its treaties of cession 120 years ago. And these were to respect the rights of the traditional chiefs and the local property laws. These laws prevent land from being owned by non-Samoans, and they permit only chiefs to be elected to Samoa's Senate. To help preserve this, there is no U.S. district court. The Constitution is only authorized and approved by the Secretary of the Interior and subsequently by the Congress. Again, the issues that many people relate to status are more the application of federal laws. For example, the Commonwealth proposal in Puerto Rico's 1993 plebiscite asked for the national program for aid to the aged, blind, and disabled, supplemental security income, which was hidden in the Northern Marianas Covenant, equality and nutrition assistance, which Puerto Rico had gotten initially and lost, and which the Virgin Islands and Guam still have, and trade protection for local products, and a reversal in the tax credit that companies could take at the time for income they claimed was from Puerto Rico, whether it was really attributable to work in the territory or not. All of the worse than equal treatment in federal programs in all of the territories goes back to the exemption from federal tax laws in that first insular case. It isn't, however, really because of the insular case's ruling about the non-application of the Constitution in a broader sense. The Supreme Court ruled in 1980 that it's the territory clause itself, not the insular cases, that enables the Congress to treat territories differently so long as it has a rational basis for its actions, a very low constitutional test. And the court gave reasons. The exemption from tax laws was a primary one. In any case, the Supreme Court had ruled way back in 1957 that neither the insular cases nor their reasoning should be given any further expansion. Congressional committee chairmen have explained publicly and privately in government meetings that Puerto Rico's lesser treatment in Medicaid and the non-application of SSI is due to the exemption of income that companies in the states can claim was attributable to work in Puerto Rico. The exemptions were long misunderstood to be billions of dollars of economic assistance to the islands, although they really were billions of dollars of economic assistance to the companies. The economic model stemming from the first insular case has been a failure for Puerto Rico. Its economy remains underdeveloped. Its economy failed to keep pace when it grew. It's been in decline for the past 14 years, with future projections negative. And even with 65% of all Puerto Ricans having abandoned the territory for the equality of opportunity to which they're entitled as Americans in a state, 45% of those who remain live in poverty. So, is the answer to reverse the first undemocratic insular case, holding with its racist rationale, even if that was primarily directed at a territory that long ago became a nation? No, that's not the answer. That would put all of the territories theoretically on the path to statehood, and it would apply all taxes that apply in the states. It wouldn't constitutionally require equal treatment in programs, although I think that would come politically and maybe judicially later. Puerto Rico is conceivable as a state, but are the others? Even in Puerto Rico, a transition would be needed in taxes for which the Constitution doesn't provide. Perhaps the U.S. could rush to make territories that couldn't be states independent, but nationhood, like statehood, should be based on votes by a majority of the people. And citizenship would be a problem in the territories other than Samoa. Filipinos who were U.S. nationals when the Philippines became independent sued to retain their U.S. nationality. But the Supreme Court ruled that the Philippines really wouldn't be a nation if all of its people remained U.S. nationals. Generally, the U.S. can't deprive a citizen of their citizenship, but it would certainly discontinue granting citizenship based on birth in the islands if a territory became a nation. And it would not want all of the citizens of another nation to be U.S. citizens. The U.S. taxes its citizens in other countries. Would the entire citizenry of another nation want to be taxed by the U.S.? There are reasons that the Supreme Court hasn't reversed the insular cases. Too much time has passed. too many developments have occurred. The U.S. has unincorporated territories that may remain that for an indefinite period longer. These and other problems of reversing the insular cases are so enormous that the real agenda of some promoters of the idea is to force the U.S. to create a new kind of permanent political status with, say, a vote in the House of Representatives but no senators, exemptions from taxes and some other laws, and equality and benefit programs, or other combinations. The difficulty of this, and what really are more Commonwealth ideas, is that it would require a constitutional amendment to which the states surely would not agree. And they shouldn't agree. The U.S. is a nation of equal states. There shouldn't be a first-class statehood and a permanent second-class statehood. Others have similar ideas for what they call free association for Puerto Rico. But it would not really be free association because it would include U.S. citizenship and, for some, permanent union with the U.S. That would be a limitation on the power of the U.S.'s sovereignty that would really not mean that the U.S. was no longer a sovereign nation. Sovereign nations can determine their associations. For good or ill, the status options are what they are: statehood, independence, and nationhood in an association with the U.S. that either nation could unilaterally end, and unincorporated territory status. This is also the reason that the Justice Department in 2017 and the U.S. House of Representatives in 2010 said that unincorporated territory status had to be an option in a plebiscite in Puerto Rico on all status options. The application of laws and programs could be made better to the territories, but the biggest impediment to that is Puerto Rico and its size, its population, its poverty, the cost. The George H.W. Bush administration seriously considered extending SSI to the southern Mariana Island, Guam, but then it realized it would have no argument to not extend SSI to Puerto Rico. The cost estimate for Puerto Rico just a couple of years later, when I was in the White House, was $925 million. In 2010, the cost had grown to $1.9 billion. That's why the governor of my home territory, the Virgin Islands, told the Senate Territories Subcommittee just a couple of years ago that the best action that it could take for the less populated territories was to make Puerto Rico a state. Now that's his advocacy for statehood, and it's not mine. For me, Puerto Rico can become a state or a nation, whichever the people want. It should not, however, continue to suffer as an unincorporated territory without democracy and equality in the nation of its choice, when it has a choice, and it should not continue to make the other territories suffer. Impossible proposals, whether called Commonwealth or free association that's not really free association, are just a delaying tactic that supports the status quo. There are people here who support the status quo. There are people who do well under the status quo. They do very well. There's tremendous income disparity in Puerto Rico. And the beneficiaries are primarily companies from the states that are profitable and multinational. They're individuals from the states who are wealthy and have high incomes. And they're professionals in Puerto Rico who serve these people. But the beneficiaries are not most of the people of Puerto Rico. And with Promesa and the Sanchez-Valle decision of the Supreme Court in 2016, even the most ardent Commonwealther has to acknowledge that there is not and cannot be a status such as they have envisioned. The status should be the people's choice as long as the option or options on the ballot are possible ones. Now, not everyone agrees with that either. As the House was about to pass a status resolution bill in 1998, some Commonwealthers went to the most nativist and right-wing groups in the U.S. to urge them to oppose the possibility of equality within the U.S. if Puerto Ricans wanted it. They placed newspaper ads that suggested Puerto Rico shouldn't be allowed to be a state because of the rates of unwed birth mothers, crime, and poverty. Some have continued going to English-only groups to oppose equality for a community in which Spanish is the predominant language. These are people who apparently haven't been to areas that I've been to in Miami or the Bronx. Their primary tactic, however, is to go to Republicans and oppose Puerto Ricans having voting representation in the government that makes their national laws and their local laws when it wants to, because Puerto Rico might be more democratic than Republican. Nationhood is a noble aspiration. I'm 100% in favor of Puerto Ricans who want it, advocating for it. But recently, some nationalists were reported to have thanked the U.S. Senate Republican leader for opposing statehood as an option because Puerto Rico might be a more democratic than Republican state. In 2014, though, a Republican Congress passed President Obama's proposal for a plebiscite on an option or options proposed by Puerto Rico, found by the U.S. Department of Justice to not be incompatible with the Constitution, laws, and policies of the U.S., after Congress has a chance to review the decision. The elected government of Puerto Rico now wants to have a plebiscite on statehood, which is a possible option. And actually, that's an idea that was proposed by the Commonwealth Party when Congress was considering a bill for a plebiscite on multiple options. Now that same party is saying it's unfair because the other options aren't on the ballot. But they really are. They're represented by the option of voting no. Many also argue that plebiscites don't work. After all, Puerto Rico has had 5 plebiscites and the U.S. hasn't changed its status. But let's look at the facts of those plebiscites. The first in 1967 was won by a proposal that was named Commonwealth, but was for a vastly different governing arrangement than the current one, combining aspects of nationhood, statehood, and unincorporated territory status. A joint federal territorial commission at the highest level developed a more specific proposal from it, but it was rejected in Congress and by the president in the mid-1970s. A second plebiscite in 1993 was conducted only under local law. It included a much less ambitious but no more realistic Commonwealth proposal, but that proposal only obtained a slight plurality of the vote over statehood, and even so, its substance was rejected by the president and in Congress. The third plebiscite had all 4 possible status options, reasonably defined, but it also had a none of the above choice, an impossible option, because there is no none of the above, except going back to Spain or association with a nation other than the U.S., which have no support. The fourth plebiscite in 2012 followed the flawed process recommended by the George W. Bush and Obama administrations. The options were real ones, but they split into two questions. First, yes or no on the current status, and the second on the possible alternatives that have some support here. Statehood, independence, and a true free association. The current status was rejected, and statehood won on the second question, but many people didn't choose an alternative in the second question. And the Commonwealth government that was elected at the same time lobbied the federal government to not act, saying that the vote was unfair because it didn't include a Commonwealth proposal. The federal government did respond, however, with the 2014 law. And the purpose was to ensure that the result would be clear and claims of unfairness would not have any credibility. Unfortunately, the territorial government went ahead with a plebiscite in 2017 with all of the four possible options in one question, but without waiting for federal approval that was likely from the Justice Department, since the territorial law for the plebiscite was amended to conform to Justice's suggestions regarding the options. Again, many people didn't vote. Nationalist leaders objected to the inclusion of unincorporated territory. Commonwealthers argued Justice hadn't approved the ballot. So the problem hasn't been in choosing a status by plebiscite, the most democratic way, but the way that the plebiscites themselves have been conducted. Now, some people opposed to statehood have proposed a status assembly instead of a plebiscite. A week ago, there was a major proposal in this regard. The process would involve an elected Puerto Rican assembly negotiating the terms of statehood independence and free association with the U.S. with a joint U.S. executive and legislative branch commission. If the territory couldn't get the federal government to enact a federal law for such a commission, it would go ahead and elect the assembly on its own. The negotiators would commission studies on citizenship, taxes, debt, culture, language, mutual security under different status options, and possible transitions on language in schools, government, and courts under statehood, citizenship under free association, and trade and financial agreements under independence. The assembly would then choose a status and put the choice to a referendum. There are a couple of fundamental problems with this. Most of what were identified as issues really aren't questions, and most of the questions are really only about free association. Statehood is defined in the Constitution, independence in international law and practice. Some matters can be negotiated in free association, but many of the questions are answered by the nature of what Puerto Rico's status would be, a sovereign nation. And there are precedents in the U.S. for free association. More basically, the reality is that the U.S. would only concede as much as it might if confronted with a demand for nationhood. And this is also true regarding questions of the transition to statehood or independence. This became particularly evident in the status resolution process in the federal government in 1989 through 1991. Even a statutory high-level U.S. commission can't take definitive positions on a hypothetical basis for three different statuses on which Puerto Ricans can rely that Congress will adopt. In any case, Puerto Ricans would have citizenship by virtue of the Constitution under statehood. Citizenship would not continue to be granted based on birth in a nation of Puerto Rico. Most likely, Puerto Ricans resident in Puerto Rico at the time of nationhood would be able to elect U.S. citizenship or become citizens in the new nation, but not both. Taxes would be equal with the taxes in the states understated. The U.S. would not tax Puerto Rico under nationhood, except it would tax U.S. citizens and U.S. corporations. The U.S. will not forgive Puerto Rico's debts or pay them. The U.S. could impose language requirements that it does not apply to other states in a statehood admission bill, but when Puerto Rico became a state, it could ignore the requirements under the 10th Amendment. There have been failed efforts to legislate a national language since the first Congress. There were 2 amendments to impose intrusive language requirements on Puerto Rico under statehood in bills that passed the House in 1998 and 2010, but the amendments were handily defeated. The U.S. would be responsible for Puerto Rico's security under statehood. It could be responsible for Puerto Rico's security under nationhood, but that would presumably require base and other rights, including the right to limit the access of other nations to Puerto Rico and its waters. Congress, made up of many individuals, answers questions through legislation. So there is really no purpose to a status assembly. It would also be less democratic than a plebiscite. The real purpose of an assembly is to hope that anti-statehood delegates of various viewpoints outnumber statehood delegates, and they can unify in a way that they would not in a plebiscite. Based on Supreme Court jurisprudence, the Justice Department has reversed a position it once held on the fundamental concept that's necessary under Commonwealth: mutual consent. One Congress cannot give up the territory governing powers of a successor without making a territory a state or a nation. The U.S. as a sovereign nation cannot be bound to a political agreement with another nation. So Puerto Rico and the other territories are left with the status options that I've mentioned: becoming a state, becoming a nation, whether independent or freely associated with the United States, or remaining colonies. Thank you for listening.
Thanks to Farrow for such an insightful presentation. We move on with the agenda with the first discussion panel. It will be focusing on the history and development of the territories. Allow me to clarify that the panel will not be addressing questions directly from the audience here. Instead, anyone here in the audience or anyone joining through the internet may propose a question by accessing the event webpage encuentrodeterritorios.com. In this page, there is a form to submit comments or questions which will be accessed by the panel moderator, and the questions will be addressed depending on the time available within the panel discussion. We encourage you to be brief and concise in the questions and to limit one question per form. Our guest panelists are Dr. Robert Underwood, former delegate in Congress for Guam and former president of the University of Guam; Dr. Carlisle Corbin, former Minister of State for External Affairs of the United States Virgin Islands; Professor Kenneth McClintock, former Puerto Rico Secretary of State and former President of Puerto Rico Senate. The moderator for this table will be Celina Romani-Siaca, attorney, feminist, human rights activist, and former president of the Puerto Rico Bar Association. Please welcome Celina and the panelists. Also, allow me to read a note excusing 2 panelists for the panels we are having later on. Queremos excusar al presidente del Colegio de Abogados, licenciado Edgardo Román, y al decano de la Escuela de Derecho de la Universidad Interamericana, el licenciado Julio Fontanet, quienes se encuentran en este momento en los actos fúnebres del líder independentista Rafael Cancel Miranda. Nuestro pésame a sus familiares, allegados, así como a la comunidad independentista.
Muy buenos días. Good morning to all. And we are very honored and excited to have this panel confirming this special guest. First of all, I'd like to identify that we're going to try to have a conversation, although in the first part, they're going to have a 10-12 minute time to present some ideas, and then they're going to continue talking to each other. This panel, as it's actually been identified, is supposed to underline the historical developments of the territories under the U.S. Constitution. And I think what it's important, especially after listening to Mr. Farrow, is that this is not just a question of historical interest, but essentially how the U.S. territorial policy reflects an uneven and incomplete democratization of the American polity. And I think it's important to assess both the domestic U.S. constitutional level, which we're going to be listening to, and as well the international level in which Dr. Corbin is going to be also talking about. I think also it's important to understand that at the level of the international law, an important question is how long can Puerto Rico and the other territories escape accountability under international norms? Is something that we cannot pass on and overlook. And also for how long can it court, the U.S. can court a narrative of post-colonialism. 19th century was a century of empire. 20th century was supposed to be a century of decolonization, and 21st century, what is this century about? Listening to also Mr. Farrow, we just realized the difficulties of being negotiating on equal terms. You're negotiating with the colonizing power, who has the last word. So that's some of the questions that we also have to address in underlying the issue of what's the political status that awaits these territories in an effort to democratize more the relationship between the U.S. and themselves. I have here three special guests. The first one is Dr. Carlisle Corbin. He has various political roles, and he's qualified as an expert in international relations. He's the former Minister of State for External Affairs of the U.S. Virgin Islands and the territory's representative to various United Nations bodies. And parallel to his role as the U.S. Virgin Islands UN representative, Dr. Corbin is also recognized as an UN development representative program on governance to Bermuda, to the Turks and Caicos Islands. He has also served as a political advisor to successive chairs of the UN Special Committee on Decolonization and Secretary General of the Offshore Governors Forum, comprising the governments of American Samoa, Guam, the Northern Mariana Islands, Puerto Rico, and the U.S. Virgin Islands. We also have, if I find it, Dr. Underwood. Dr. Underwood is a former member, welcome Dr. Underwood, of the U.S. Congress, and recently retired as the longest serving president of the University of Guam. He has served as a high school teacher, curriculum writer, administrator, dean of the College of Education, and academic vice president in his professional career. He is a distinguished scholar with many publications on education, regional political issues, indigenous concerns, and cultural change. He's widely quoted in many publications regarding Guam's history, politics, and cultural issues. He was active in community and cultural issues early in his life. He was a passionate organizer of demonstrations and community activities on behalf of political status change, maintenance of the Chamorro language, indigenous rights, and a more sustainable island community. He served as the congressional delegate from Guam in the 103rd, 107th Congress, 1993 to 2003, during which he sponsored major legislation for Guam, playing an active role in Department of Defense authorization bills, and was a forceful advocate for political development for insular areas. He's also played a national leadership role in Asian Pacific American issues, especially in educational opportunities and legislation. He has also served on numerous boards and commissions, including service as chair of the Chamorro Language Commission, the National Board of Educational Sciences with the Obama administration, the Guam Board of Education, the founding member of the Guam Humanities Council and National Advisory Council on Bilingual Education under the Carter administration, American Folklife Center Board of Trustees, and many other things appointed by Speaker Pelosi. Nuestro Kenneth, welcome Dr. Underwood. Nuestro Kenneth McClintock, as you know, he served... Tienes madre, es verdad. ¿Cómo puedo haber olvidado eso? Kenneth McClintock Hernandez served as the 22nd Secretary of State of Puerto Rico, one of the 4 longest serving in that post. He also served as co-chair of the Hillary Clinton's National Hispanic Leadership Council in 2008. He co-chaired her successful Puerto Rico primary campaign that year and served as the 13th president of the Senate of Puerto Rico until December 31st, 2008. He also chaired Luis Fortuño's incoming Committee on Government Transition in 2008 and the outgoing Committee on Government Transition in 2012, the only Puerto Rican to serve in both capacities. He was sworn into office as Secretary of State on January 2, 2009 by Chief Justice Federico Hernández Denton, fulfilling the role of Lieutenant Governor in the island. Bueno, pues welcome to these panelists, bienvenidos, y empezamos con el Dr. Underwood. Should we start with you, Dr. Underwood?
Okay, buenos días a todos. Hafade Manelud and Manainaho. It's an honor and a privilege to be here this morning. I'm here representing, I guess, an historical perspective on the experiences that Guam has had relative to political status. And I think I would best outline it this way. I'm a proud descendant of the Chamorro people of Guam, who have the distinction of being the first Pacific Island people to settle what we now call the remote Pacific, which is the group of islands before all of Micronesia was settled, certainly before all of Polynesia was settled, and certainly most of Melanesia was settled. Guam is also the first island to be encountered by Europeans. And so the 500th anniversary of that event comes up next year in 2021 with the commemoration or the celebration or the castigation of Magellan's circumnavigation, and I'm assuming commemoration, castigation, and celebration will all occur simultaneously in some fashion. So Guam was also the first Pacific island to be colonized by the West. In fact, the great anthropologist Douglas Oliver said the rape of Oceania began with Guam. Guam was the first Pacific island to be taken by the U.S. in the Spanish-American War. About 6 days after the annexation of formal annexation of Hawaii, and about 5 weeks after the attack on San Juan by the U.S. Navy. Guam is the only U.S. Territory that was occupied by an enemy nation in World War II. Guam is the first U.S. territory in the Pacific to be given an organic act by the United States. So what does being first mean when you're all of those things that you are first? Well, the first Commonwealth to be declared in the Pacific was the Commonwealth of the Northern Marianas in the 1970s. So apparently, in keeping with the biblical admonition that the first will be last and the last will be first, Guam is still awaiting its ultimate political definition. This is, ladies and gentlemen, this is a perennial issue that involves the small territories, and has, Mr. Farrow has eloquently outlined, a lot of it has to do with the size and scale of what is going to happen to Puerto Rico. That has a lot to do with it. It also has a lot to do with all of the legal distinctions, the cases, all of the issues that have surfaced, primarily with Puerto Rico. A little bit with the Northern Marianas as well, as the experience with the Northern Marianas being granted certain authority, perhaps did not exercise them as well as they could, or as perhaps as the U.S. Congress thought they should. So here we are at the end of the day trying to understand what will move us off the dime in resolving these issues. And it is tempting to say that there is something defective in the way that we are pursuing this. It's tempting to say that the attempt, as Mr. Farrow has outlined, the attempts to acquire Commonwealth by Guam starting in the late 1980s and ending in the mid-1990s was somehow defective on our part. It's also tempting to say that we are deficient as territories in some fashion, in our relationship, in our loyalty, in our whatever it is that our relationship to the United States. But I think at the end of the day, we have to say that the American nation as a whole certainly does not consider us as important issues. And that is the source of trying to figure out how do we triangulate interest and concern and meaningful policy. It is clear that the three most meaningful options are indeed statehood and independence and free association. Unincorporated territory is a kind of a default option. And of course, we have none of the above, which is, as indicated, not an option at all. But how are we going to reach that level where we kind of triangulate a new course of action? Of course, it's tempting to say that if we would just work with the Puerto Ricans, and if Puerto Rico would just figure out what it wanted to do, then the rest of us would figure it out subsequently. And so, it's easy for us to sit here and say, Kenneth, why don't you guys just figure out what to do, and then the rest of us can get on with our lives. So that's a tempting option. But maybe a more engaging and more realistic option is to find a way to work with the Puerto Ricans. Maybe to find a way to develop strategies. And of course, there's two kinds of strategies that are at work here. One is a vision. What is a political vision? A political vision is what you want to be when you grow up. What you want as a status that encompasses your values, that gives meaning to your history, that allows you to fulfill your potential. The other are just kind of political promises, like what program are we going to get involved in? What program are we not going to get? What if we do this? Will we get that program? So a lot of people are focused on the kind of individual programmatic issues, and some people are focused on the visionary type issues. What political status will grant us the vision of being able to fulfill our potential that is respectful of our past and that honors our ancestors? That's a tough order. That's a tough order. But I think it's one that is the only approach we can get. You know, I always like to say this with students when I was president of the university. I said, you know, John F. Kennedy said, we choose to go to the moon not because it's easy, but because it's hard. Now, John F. Kennedy could have said, we choose to go to the moon and the Soviet Union's going to pay for it. Or we choose to go to the moon and don't worry, it's not going to cost us a lot of money. But that's not what he said. He instead articulated a vision. That's the source of where we need to go as island societies, and as island societies that are respectful and mindful of each other's common experience. And every time I come to Puerto Rico, I'm reminded about that. I'm reminded about the engaging demeanor of people, the commonality of food and the commonality of the cultural experience. But I'm also reminded of the differences. I'm also reminded of the distances. And I'm also reminded that somehow or other we need to learn more from each other. So I hope we're able to do that today. Thank you very much.
Muy buenos días. I'm so happy to be back in Puerto Rico. I had my good meeting with my good friend Aaron Ramos yesterday. I'm reminding of the fact that my four parents on my mother's side are from Ponce. And of course, the direct link between Puerto Rico and the Virgin Islands historically is very strong and remains strong. Entonces, yo soy ponceño también. As indicated, I would wish to speak a bit about the international dimension of this political status of the territories. U.S. territories are not unlike territories around the world, particularly in the Caribbean and Pacific. Most of the 17 remaining territories are in those regions, with the exception of Western Sahara, Falkland Islands, Malvinas, Gibraltar. But the most of us are in small island territories in both regions of the Oceania and the Atlantic Caribbean. So I'll deal with that a bit. First of all, the U.S. has two territories in the Caribbean, of course, the two Puerto Rico Virgin Islands, but also American Samoa, Guam, and the Northern Mariana Islands in the Pacific region. The British have 6 territories in this region: Bermuda, Turks and Caicos Islands, Cayman Islands, Montserrat, British Virgin Islands, Anguilla. The French also operate, interestingly, in the Caribbean as well, with some 8 territories combined between the Pacific and the Caribbean. Those of you know Martinique, Guadeloupe, French Guiana, which are integrated fully as synonymous to states of the United States. You have in the Pacific region, French Guiana, and also Wallis and Futuna and New Caledonia. My work in recent years has been with respect to French Guiana, with respect to French Polynesia, which is the most recent territory to be relisted on the United Nations list, much to the chagrin of the French. But in fact, their relationship was deemed to be insufficiently autonomous to be considered anything other than a non-self-governing territory. Many of the other territories around the world are also in that position, in which we refer to in dependency governance studies as being in the dependency periphery. They're below the standard of full self-government, but they're yet not able to get on the UN list, because that list is, to attain participation on that list is a very political event, and the large states block that successfully thus far. Now, there are rules, of course, finally, the Netherlands operates in our region, primarily in the Caribbean, although they were once in the Pacific with Indonesia. But in the case of currently, the Dutch have some 6 territories in the region: Aruba, Curaçao, and St. Martin, which are considered autonomous countries in the region. But in effect, if you examine their governance structures under the self-governance indicators that we have created, it has become clear that there are some clear deficiencies. They have, particularly in the area of their control of their financial management, which sounds familiar in Puerto Rico, I'm sure. This is also a fundamental initiative in the British territories as well. The Dutch have Bonaire, Saba, and St. Eustatius, which are not considered autonomous, but rather have been annexed to one of the countries of the Netherlands, which is Holland. And of course, one of them's government was abolished, St. Eustatius, on the basis of some concerns, and they're presently under direct rule, which is something happened similarly in around 2012, I believe, no, 2009 perhaps, in the Turks and Caicos Islands, where the British abolished the government there. So you have a consideration in the British also, again, with those 6 territories. So in effect, all of these territories are governed under in reality, what does govern the political future of these territories is the United Nations Charter, and in particular, Article 73B of the Charter, which clearly relates to the fact that these territories are, in effect, in a position of preparatory arrangements. They're in preparation for full self-government. And I think that Article 73B establishes the obligation of the countries that administer these territories to bring the territories to full self-government. Of course, in our case, we have this obligation, therefore, has transitioned the territories from being preparatory in perpetuity to the question of a preparatory phase, whereby we have transitioning from territorial status to full measure of self-government in one of the 3 options which has been described by Jeff Farrow and Dr. Underwood, independence, free association, or integration. Now, integration and free association in the U.S. context is probably the least flexible of all. If we look at other, particularly free association arrangements around the world, you will find a very broad, a much broader perspective. Take Cook Islands with New Zealand. Take even our own, which I say our own. Jeff would be aware of certainly the fact that we were under Denmark while Puerto Rico was under Spain. And during the time of Denmark, the evolution of territories that Denmark had included Greenland and Farrow Islands, which are very autonomous arrangements today. But the one thing that links both Greenland and Cook Islands is the fact that they have citizenship of the larger country, whereas this is something, so that the Cook Islanders are New Zealand citizens, the Greenland persons are in fact Danish citizens. But of course, in the context of the U.S., the argument is you can't have that and have free association. So it's quite an inflexible approach. Now, the territories have gone through various periods since the acquisition, 1898, with the Spanish-American War. And of course, all of the territories have been acquired on the basis of some military consideration or the other. In the case, obviously, 1898, end of the Spanish-American War, the spoils of the war. In our case, Virgin Islands, it related to World War I. And so the territories have gone through various periods. I'll just outline them briefly. The military dependency governance, whereby the governments were controlled by the military. Started in Guam, in the case, it was a Spanish military governance through the Catholic Church, and then subsequently the military governance under the U.S. This was then transformed to a position of appointed dependency governance, whereby the person who was the head of the government was appointed by Washington or by, in this case, the other territories in the same vein. We went from there to what we referred to as partial elected dependency governance, where the governor was still appointed, but there was a legislative body that had legislative making capacity. And then we transitioned to where we are today, and that is full elected dependency governance. And he said we have both the government, the executive, as well as the legislative branches are elected. However, the key is that it's still dependency governance, and it does not constitute the full measure of self-government because the territories remain under the unilateral authority of the larger country. All of the territories, in a broader sense, the British, the French, the Dutch, the Netherlands, all the United States, all have this source of dependency governance. In our case, obviously, it is the territorial clause. In the case of the British, it's the various parliamentary acts, because the United Kingdom does not have a written constitution, but there's the parliamentary acts, the judgments, conventions, and of course France. In the Constitution, there's reference to each of their territories specifically, and then in the Netherlands case, there's a kingdom charter, which also makes reference to those territories. And of course, this source of unilateral authority is actually undertaken through various instruments. In our case, the Virgin Islands, we have the Revised Organic Act of 1954. Puerto Rico has its constitution. The British have the constitutional order, which is given to them by the British. The French have the constitutional organic law, which is similar to the Organic Act, and it's basically something given to them, which gives some degree of differences between the competencies. And of course, the Kingdom Charter has their internal constitutions as well. Now, the world has gone through several periods, 3 periods essentially of decolonization. The first period beginning at the United Nations, 1946 to 1960, where discussions began on what to do with territories. From 1960 was the adoption of the Decolonization Declaration. And of course, in the companion resolution 1541, which gave minimum standards for the 3 options: independence, free association, and integration. That period was the colonization acceleration period. Many territories attained full measure of self-government during that period. And then 1990 came, and I think Jeff Farrow mentioned the issue of the Cold War. That was a very important historical point, because the Cold War ushered in a period of decolonization deceleration, whereby the whole issue of decolonization was reframed. And we're now in that period, which actually began as far back as 1990. And it not only was it decolonization deceleration, but it was also, and we are seeing this quite a bit today, decolonization legitimization. So now the current arrangements that we have, the territorial arrangements, are considered to be, all of a sudden, they're being given a certain legitimacy that they did not have before. And so I think perhaps part of the reason why there was a suggestion to place Commonwealth back on the ballot in Puerto Rico in the referendum was because it was given a legitimacy. So that sort of the idea that the territorial status is a legitimate one to maintain, although it's really does not meet any international standards of the full measure of self-government. Let me just conclude by the fundamental questions as to whether we should proceed. All of the territories should continue the pursuit of the full measure of self-government, or whether we should accept dependency reforms. And I think part of what we are doing, the incremental gradualism approach, which is undertaken, which is really not something new, but it goes back a long way. In the case of U.S. territories, the idea of presidential vote and vote in the House, and I think the current Guam delegate, Mr. San Nicolas, has a proposal for the issue of delegate in the U.S. Senate. So there are a number of incremental arrangements that are being considered, but these do go back as far back as Ron DeLugo. I'm sure you know that name. who was our first delegate in the U.S. Virgin Islands, and some of these proposals came up even then. The issue, of course, is even if with these arrangements, if they are in fact approved, the question becomes whether or not we have reached the full measure of self-government as defined in the United Nations Charter, and obviously that is not necessarily the case. Now, in the end, the fundamental question, once again, is whether we are content with reforming the status quo. Can the status quo be reformed? Can it be legitimized, modernized, etc.? Or, in fact, do we really have to proceed to the full measure of self-government? And I think that's a fundamental question that we should examine at this moment. And I thank you.
Buenos dias, to keep on with the tradition. The United States has 5 very diverse territories. Almost all were acquired within a 20-year time span between 1898 and 1917, a very short imperialistic spurt, if we can call it that. All use English as an official language, and most have a second or third language, ranging from Puerto Rico Spanish, American Samoa Samoan, Guam's Chamorro, and CNMI's Chamorro and Carolinian. We are so very different historically, ethnically, racially, and culturally, to the point that some of us drive on different sides of the road, or at least at the Virgin Islands. We are, however, painfully joined by our democratic deficiencies. Under current law, the U.S. Constitution applies to us in a very limited fashion. None of us enjoy fully the promise of self-government contained in our country's Declaration of Independence, but we do elect our governors. We elect our legislators. Don't we enjoy self-government? After the approval of Promesa, written for Puerto Rico but potentially applicable to any territory in financial trouble, we don't quite have full self-government. If you have any doubts, take a look at the Sanchez Valle case in 2016. It may not be soon under a conservative Supreme Court, but I'm certain that there will come a day when a more reasonable majority in the court will start inching to a posture stating that the Constitution follows the flag and that this court-created limbo called unincorporated status, conveniently designed by several racist justices at the turn of the past century, must give way to the promises of the Declaration of Independence and the Constitution, drafted, proclaimed, and ratified a century and a half before that. Promises such as the one that all men are created equal and endowed by our Creator with certain unalienable rights, and that none of those rights can be secured unless it's under a government that enjoys the consent of the governed, are the basis for creating a new nation. None of America's territories enjoy full self-government. In these days that I've seen Democratic candidates wiggling around and trying to carefully wordsmith statements about Puerto Rico, I'm reminded about what they don't want to say because it may sound too harsh to the 20% of Floridian Puerto Ricans that don't want their native island statute resolved, and the 30 or 40% in our islands of Puerto Rico that also would prefer to stay in a limbo. However, I believe that there will come a time where the Supreme Court will say that full equality applies to every citizen living under the Star-Spangled Banner, and that the territories will have to decide whether they wish to live under full equality as part of the country or set off and become a country of their own, such as the republics of Cuba and the Philippines during the first half of the 20th century, and the various associated republics in the Pacific in the second half. 3 years ago, on April 5th, 2017, as part of the successful efforts to derail the Justice Department's approval of the political status referendum ballot of that year, 8 Republican senators insisted that despite statutory language that requires that the referendum ballot only contain, quote, options that would resolve Puerto Rico's political status, unquote, the current status, which is not final nor permanent, be included. The continuation of the current status as an unincorporated territory does not resolve our political status, leaving us indefinitely under the property or territories clause of the Constitution. No Democrat in his right mind should be supporting the requests, unsupported by the facts or a reasonable reading of the Constitution, of a learned scholar such as the lead senator who signed that letter in April 2017, Roger Wicker, the Deep South Republican senator from Mississippi, whose only link to Puerto Rico is that his now middle-aged daughter was once hired and worked for an anti-statehood administration in Puerto Rico. This important forum, which the Governor Piñero Museum has organized, can serve as a source of wisdom for the policy staff of Senator Sanders and Vice President Biden, the two candidates remaining, Biden being the younger of the two alternatives, as they try to deal with platform planks regarding America's territories from the island of Guam in the Pacific to the island of St. Croix in the Atlantic. And I would say that one of the byproducts of this forum, if we get to transmit the information that is displayed here, will be for them, who are the only two people who can do something about changing the circumstances in the territories, since the incumbent president does not want to do so, will be able to benefit from this forum. And now I'm going to keep it short and just look forward to the people's questions, which Sanina, our able moderator, will be formulating to all of us.
I think that, is it on? Okay. I think one important thing that came out across from the different presentations is first the importance of underlining the commonalities and obviously the differences. But one of the things that I was struck by in terms of Dr. Underwood's presentation was this distinction between the political vision and the individual programs. I think I'd like you to elaborate a little bit more about how to go about in formulating this political vision, which takes into account, definitely, as you well pointed out, the historic, the nation's history, the cultural element, that are not necessarily too well recognized in some of the formulas of combating or questioning the territorial status. So,
well, thank you. Thank you for that question. The issue always strikes me is that when you're in political office, certainly you ostensibly are required to present a political vision, a vision about the jurisdiction that you're representing. And when you represent a jurisdiction that is in essence a colonial jurisdiction, you're required to present a kind of a vision as to what do you want to see in your relationship with Washington, D.C., that will speak to not just your future, the fulfillment of your potential, but in a way honoring your present and honoring your past. And that's a kind of an historical lesson as well as a political lesson, as a little bit of future thinking. Most of the time, however, you're kind of not dragged into, because these are important issues, but you're really dealing with issues about taxation or participation in federal programs, and sometimes we mistake the participation in federal programs as a kind of a substitute for what is ultimately an underlying political relationship. So, you know, this is a kind of a favorite way of explaining it sometimes to people. I don't know whether, I'm assuming that all the territories tap into the federal highway funds. None of the territories really put any money into the federal highway funds. It's, you know, people who gas their car in California and Hawaii that are putting money into the Federal Highway Trust Fund. But we all kind of tap into that. And then we, at the same time that we tap into it, we complain that we're not getting enough, or that we should be getting more, or you know, are we not first-class citizens? Are we not, you know? And so we tend to think of participation in these individual programs as representative of that. Whereas in essence, you're really trying to articulate a trajectory between where you think you should be going as a potential nation or as a potential dependency. And you have to kind of confront those issues. And that's basically, I think, what is sometimes, because it's articulating the hands-on political issues. Of course, when you're a small territory like Guam, sometimes your your participation in these programs are constrained by the possible participation of Puerto Rico, which is so much larger than the rest of us. And in many ways, you know, I talk to people from the VI, and they say, you know, sometimes the VI looks at Puerto Rico as their big brother. And sometimes people say, well, Guam looks to Hawaii like their big brother. And I always say, well, you know, your big brother, just like your big brother, sometimes they help you, and sometimes they get in your way, you know? And so that's the issue that you have to contend with, that is a particular permutation for trying to represent a small territory.
Dr. Underwood, a big brother or big sister, too?
Yeah, that's right.
Kenneth and Dr. Corbin, could you also comment on this, you know, this dimension of the possible, you know, dichotomies that we experience advancing a political vision and sometimes getting lost in the forest of by the trees with the individual programs?
Well, on behalf of Puerto Rico, I want to apologize to our fellow territories, because as the governor of the Virgin Islands pointed out, as Jeff Farrow said, he said that Puerto Rico being admitted into the Union and getting us out of the way is the best way of helping the rest of the territories. And the truth is, it's because the principles that Selena is mentioning come into an encounter with budgetary realities. And what may be a $50 million a year inclusion for a territory in a federal program in which we are all discriminated, $50 million, that's nothing. But then if they do it for Guam or American Samoa or the Northern Mariana Islands or the Virgin Islands, then you have to include Puerto Rico, and Puerto Rico it's $650 million. So then budgetary realities with respect to Puerto Rico force discriminating against the rest of the territories where they could get them all included for a fraction of the cost. And in politics, that is a reality with regard to virtually every issue. You know, principles have to confront budgetary and political realities, and that's why sometimes things don't get done by principle.
But Dr. Underwood, I think, was underscoring also something that is important in the political vision, which is the question of like culture, history. How do you like envision that as part of the deterritorialization, la deterritorialización, decolonization of Puerto Rico?
Yeah, well, that is a...
What would be the political vision, for example, of statehood?
Yeah, well, we all have to become decolonized, and we're all colonies. In some cases, it's probably easier than others. In the case of the smaller territories, you have the problem that they may not comply with some of the Jeffersonian principles of admission. And we should try to fashion ways, and that's one of the things that I mentioned in my initial remarks. We have to see how we can fashion ways to bring the promise of the Declaration of Independence and the Constitution, that we're all created equal, that we're entitled to self-government, and so forth. How do we bring that to some territories that don't comply with all of the requirements of the Jeffersonian principles of admission? Now, on the other hand, old Thomas wasn't thinking of territories other than the continental territories between the Atlantic and the Pacific when he developed those principles of admission. So there you have to take a look at that also. But there are some basic principles set forth in the Declaration, set forth in the Constitution, that we have to find ways that they can all be incorporated in some shape or form into each and every one of the diverse territories.
I guess that part of the problem is that we don't have necessarily in the U.S. Constitution a pluralistic vision of the Constitution. For example, that was the issue with American Samoa, where tribal law privileged the issue of group rights and enjoying the privileges of land rights only to American Samoa as part of the culture. Because when the culture or the group rights are in conflict with individual rights, according to the U.S. Constitution, the individual rights prevail. That's part of the seed and center of that Constitution. Yes, Dr. Underwood.
I just wanted to add on to what Kenneth has said here, is that sure, the small territories don't cost as much, so we end up sounding like we're some kind of cheap date. We can just, you can just give them so much money and they'll be happy. So in comparison to Puerto Rico, we are a cheap date. But the issue still has to go back to, what you think you're going to, how you're going to fulfill your essence as a society. And when we speak of, Jeffersonian principles and inalienable rights, and I take great pains to point this out, Thomas Jefferson had the option of saying that these rights came to them as Americans. He didn't say that. He said they come to these rights as people. This is a human rights declaration. And so that human rights declaration applies to all. And, the emotional content obviously is sometimes there for some political status options, whereas it isn't for others. As a student once pointed out to me in a forum, Dr. Underwood, nobody ever writes a poem for statehood. They write poetry for other political status options, or they write but nobody ever says an ode to statehood. This is what we're going to get, because it doesn't seem to carry that emotional content, except as pointed out by Kenneth here, in the political context, which of course is primarily what we're talking about.
Corbin, Dr. Corbin, do you would like to comment on this before we pass on? Yes. I'm not too good with this.
Maybe you can get it. Sorry. I would just say that these are symptoms of an overall question of political and economic inequality. That is what we exist under. As we seek to deal with them in a piecemeal fashion, these issues will always arise. I believe the overall focus of moving toward permanent options, I think, is really the challenge that we face, and this will, where if we're able to achieve these things, one of a permanent option, then these issues will be taken care of.
Moving precisely to the international arena, I was actually, since this is a historical panel, you all know that Puerto Rico was removed from the list of non-self-governing territories in 1953. And I was interested in, when you mentioned this case of French Polynesia being reinscribed in the list of non-self-governing territories. What lessons, if any, can that process provide at the international sphere for Puerto Rico, especially given all the deficiencies that have been pointed out historically about the removal of Puerto Rico from that list in 1953?
Maybe that question does not want an answer. Right? No, the lesson, the main lesson, I think, is certainly how difficult it is. You had a situation in French Polynesia where the government, the president of French Polynesia, and their leader is known as the president of the assembly in their system. The president was the president of the pro-independence party, and was also a very strong anti-nuclear advocate for many years, Oscar Temaru. And of course, so his government was very strong on trying to return to the list which they had been on the original list in 1946, but were removed 1 year later when the French changed the French Constitution, changed the name from colony to territory, in which case, by virtue of that change of name, they made the case to be removed, although the General Assembly did not have anything to say about it. It was simply removed by administrative fiat. The lesson for other territories in Puerto Rico there has been expression, I am aware of expressions made that Puerto Rico should be reconsidered, and as you know, it is taken up in the Decolonization Committee under a special arrangement where the resolution only stays in the committee. It does not go to the fourth committee. But the issue of, and I understood also that it has been tried in the past, but it is a very political decision. And it took French Polynesia 4 years or more to advocate, negotiate, lobby in order to get the support. The regional support on this question was very strong. As a result, it became to the United Nations as a Pacific regional issue, even as some of the regional countries were being pressured very strongly not to support it. In the end, it was adopted by consensus, but very interestingly, the French do not participate in the General Assembly or even in the committee discussions on it. They refuse to acknowledge that it has happened. So, and sometimes, rule of law is only applies when it's in your favor.
So, what do you think are the benefits of being reinscribed in that list, if any?
Well, there's some. The process is currently in the stagnation phase, as I had mentioned before. We're in this year is the end of the third international decade for the eradication of colonialism, adopted by the United Nations. In the period from 1990 to 2020, you have one territory, or two territories were removed from the list, Namibia and Timor-Leste, formerly East Timor, and one territory was added, that was French Polynesia. Meanwhile, for that 30-year period, the movement off of the list has become stagnant. And movement off it's not so much the list. Being removed from the list, it really reflects change that has actually occurred. So it's just the end result of a change process. But there has been very little change in the context of within the territories themselves for various reasons. And I must commend Guam for its initiative, not first of all with respect to the Commonwealth proposal, which was then, after having been run its course through the Congress, the shift was moving toward one of the three options. And part of this has a great deal to do with our colleague on this panel, Dr. Underwood, who in his presidency as a university, he has developed a very strong cadre of academics there who have been very active in this area, and also was instrumental in the introduction of the course that I teach in the summers in the University of Guam on dependency governance.
Sometimes I have the impression, I don't know if it's the wrong impression, given the increased legitimization of the territorial status by the U.S. Supreme Court and the discussions in the U.S., especially in the last years, that it doesn't matter that much, that the UN doesn't matter that much. Do you think?
I have some historical experience with this because I was the first person from Guam to go to the UN in 1982 and appear in front of the committee there. At that time, at the end of my presentation, I got a couple of favorable comments from Cuba and Iraq. And so this was, of course, in the middle of the Cold War. So and I think that was a very salient point made by Mr. Farrow, that during the time of the Cold War, that created a sort of different dynamic for that. I always tell people that going to the United Nations is an important venue, but it's not the deciding venue. You know, it's important to understand that going to New York and appearing in front of the United Nations and making Guam's case, because Guam's case is not fully resolved yet, is an important place from which the people of Guam can make a case, or individuals from Guam can make a case. But of course, at the end of the day, the decisions will be made somewhere between Washington D.C. and Hagatna, somewhere in that vortex. That decision will be made. And now I have to add San Juan to that too. I'm going to add San Juan to that because San Juan it plays such an important role in how it affects overall policies. But yes, I know that Guam has been on the list continually, and of course, it should come as no surprise to anyone that the people of Guam should take full advantage of this opportunity to make their case to the international community. There is always, with the anomalous status of being an unincorporated territory, means you're neither fish nor fowl. So why not take advantage of that status while you can? And there is always some kind of level of not residual sovereignty, but a kind of international standing that is afforded you by virtue of this status. So therefore, you can participate in regional groups. You can, the Guam can participate in the South Pacific Community. Guam can participate in the South Pacific Regional Environmental Program. Guam is invited as a separate entity for many kinds of regional activities in Asia and Pacific. And it would be absurd for the people of Guam to not take full advantage of that. Not just to advertise its case for political change, but to advertise its case for economic development, social development, cultural contacts, and educational advancement. So those things flow from that. And of course, they're really important and vital and significant tools for the people of Guam to advance their agenda.
Want to comment?
Yeah, I think that all territories take advantage of the difficult circumstances they are in, and in some cases we do so as territories. In other cases, if they want to treat us as separate entities, sometimes we take advantage of that. In Puerto Rico, we're pretty careful about that, depending on what side of the political spectrum you are. President Fasal Zamora, who was immediately my predecessor as Senate President, there are organizations, international or regional organizations, where he participated in as a separate Senate, and which I had participated in before as part of the U.S. And Puerto Rico was present in both occasions in slightly different ways, but we participated. So he did it from his ideological point of view. I did it from my ideological point of view. But we found practical and pragmatic arrangements to make sure that Puerto Rico profited no matter how we did it.
Actually, what we're saying is international sphere, we can take advantage of that
Yeah.
more or less in the way that.
And when I
Dr.
was Secretary of State, you know, some people say, "Oh, we should be getting more rights and more powers and all that." I said, "Look, we only have 5 Puerto Rico commercial offices in foreign countries, and you had Oregon, which had 5 offices in the People's Republic of China, not counting all the other offices they had to promote trade with the state of Oregon. So sometimes we're not taking advantage of all the opportunities that we have as U.S. territories to promote our economic activity and job creation in our own territories by doing more business with foreign countries."
Can I conclude from your comments that international law and the UN doesn't play that a big role when territories are trying to decolonize from the U.S.? Because the U.S. essentially has adopted pretty much an exceptionalist kind of position of the international law and international law stand.
Yeah, I think what
So it's
we've
just
done.
us and the U.S.
Yeah. Well, I don't think that the U.S. pays much attention to the UN, except when it has to. And that has not been the case in the territories. If it's about Israel's West Bank or something like that, they have to pay attention. But
They haven't paid.
and
that
what's
much
that?
attention. They haven't paid that much attention
No.
with Israel.
Yeah, but if they have to, it'll be issues like that. What I think the territories have done is they've basically researched within the constitutional spectrum that we operate in to see what things we can get away with and what things we can't. And then we try to get away with whatever we can, as Dr. Underwood suggested.
Dr. Corby mentioned that incremental approach that you're just describing, the question was whether that incremental approach that we have been following, we, meaning all territory, does that really matter? Is that like a road to self-government, or should we be more drastic about it?
Well, I would suggest that there's an incremental approach even regarding this participation in international organizations. That is really a preparatory approach, a capacity building approach. I think Puerto Rico was in the forefront, and Virgin Islands also was very active during a certain period in participating in CEPAL, for example, the Economic Commission for Latin America and the Caribbean, among other regional institutions. That links us with developments in the hemisphere at the level whereby we can deal directly with our counterparts. And that's also the case with respect to Guam and its involvement in regional activities as well during a certain period. Now, I think what happens is when governments change, as Mr. McClintock has mentioned, there's maybe an ideological shift. There may be a different shift in terms of whether or not it's appropriate to have a separate representation, or whether it's more appropriate to be within the context of the territorial or the United States delegation, if you will. And we had always dealt with that issue, we having received invitations directly to participate, or whether we should participate as within the U.S. delegation. And often we took the view that if we participate within the delegation of the federal government, then we're not there. We're there. If we have our separate seat, be it an observer seat or an associate membership seat, we can speak on our own. And invariably, our positions are not necessarily inconsistent with the federal position on certain issues. But it did also assist us in terms of building capacity, and much of that capacity exists today. Those are positive elements. So that, in many ways, that's an incremental developmental process. So if there is a change to one of the options of full self-government, then there's capacity already developed in place. And also the reference to having offices in various places. We did a study on Bermuda some years ago in relation to the external affairs, what would it cost for Bermuda to become independent, for example? What are the costs, benefits to that? And the point was that Bermuda has offices in various places, London, Washington, etc. They didn't need any more than that. So the fact the transition from a trade office to an embassy was quite minimal.
Mr. Farrow mentioned the plebiscite. I think it would be for all of you to comment a little bit on what do you think, what is the route when we're confronting the situation of non-binding plebiscite part of it.
Well, first of all, Congress usually doesn't bind itself to anything. And they use the excuse that one Congress cannot bind the previous one. And most issues in Congress, because in Congress you're not famous for strategic planning. You're more famous for crisis management. Or issues take a lot more than 2 years to resolve normally. So I think that those that demand that results be binding in a plebiscite regarding Puerto Rico are really trying to place an impossible roadblock for a plebiscite to be held because they fear the results of the plebiscite. In the past 50 years, the statehood party has held 4 plebiscites, and it's proposing a 5th for November 3rd. In those same 50 years, the pro-Commonwealth Party has governed Puerto Rico for half of the time, and they've never dared to hold one single plebiscite. Well, what that suggests to me is that one party wants the will of the people to be known, and the other party fears what the result will be. And the reason for that is that our pollsters in the statehood party and the pollsters in the anti-statehood party, they may be different pollsters, but they're measuring the will of the same people. And they both know what the results are.
Leaving partisan politics aside, that's possible. Dr. Underwood, what would you think about the question of, getting involved in the plebiscite that non-binding? On the other side, where the decolonized power necessarily affect the will of the people.
Of course, I agree with Mr. McClintock here that Congress will not be binded by anything, but they will bind others. And so that's the situation we're always confronted with. The issue of a binding plebiscite and a non-binding plebiscite, of course, the only way that that works is that if everybody is bounded by it. If you can't say we're going to have a binding plebiscite and it only binds one side, unless people freely do that. And in the context of the American system, I don't think that Congress is willing to do that. I might be surprised. Maybe they'll do that in the future. It has happened in other places. Other nations do this. France did this recently with New Caledonia. They set up a process. It was politically managed. They had to deal with the issue of who counts as a legitimate New Caledonian. And they went through that whole political process, and they made a decision. And then now they had the election. I'm not sure the results were what some people wanted, but in essence, everybody had to live with it. New Caledonia had to live with it, and France had to live with it. In our instance, we're always being asked, we're asking for a binding plebiscite, but the only people who have to live with it are the people in the territories. That just doesn't seem to make sense. But of course, we should have these, and in the case of Guam, we have the very special case, of course, of trying to understand when we say self-determination is who is the self. And in that instance, because of demographic changes and historical changes, and the implicit promise made in the original Organic Act as to how people became U.S. citizens in Guam, which is that those people who could trace their ancestry back to the time of Spanish rule, is pretty clear who was being discussed for purposes of self-determination. But of course, that has been challenged in court, and successfully. So now that leaves that question up in the air. But if Congress wanted to exercise a really creative use of their territorial clause and the fact that they can treat an unincorporated territory in ways different from states, they could authorize that election, and then I think people would be content with the results. But of course, that's a long stretch, but you know, hope springs eternal if you have a vision.
Yes, on the issue of non-binding referenda, I think there are a number of examples of these non-binding referenda where the results have been ignored. In the Caribbean alone, in 2014, there was a referendum in the Dutch special municipality of St. Eustatius, where the people voted for autonomy. The Dutch ignored the result. In the case of Bonaire, the following year, there was a referendum which rejected the current status, and that was also ignored. Very recently in the Pacific in Bougainville, 98% of the people voted for independence. Now the question is being raised that it was non-binding, therefore it's unclear as to whether that would proceed, but it's difficult to ignore 98%, non-binding or not. The main context here is that these are being projected as acts of self-determination. But in reality, if the result is not going to be honored, then of course, how can it be an act of self-determination? So there is a provision in the Decolonization Declaration, Resolution 1514 of 1960, which refers to transfer of powers. And that provision must be invoked in order for the results to be considered binding.
Well, I think this has been a wonderful discussion. I really thank you, all of you. It has been very, very illustrating and illuminating. And let's share our enthusiasm with this panel by giving them an applause. Thank you.
Thanks so much to all the panelists. And now we move on to in the agenda, but before going to our next guest speaker, we are going to welcome the Secretary of State, Elmer Roman, and he will be addressing the audience. We also want to acknowledge that the Mayor of Isabela has also arrived, and he will be joining us. Yes.
Well, good morning to all those who participate in this gathering of the United States and Incorporated Territories. I understand it's the first roundtable, so welcome all. Actually, great, sponsored by the always gentle staff of the Ana Jimenez University. So it's a great initiative. Truly appreciate being here. So, Secretary of State, on behalf of the Governor of Puerto Rico, Wanda Vazquez, I welcome you to Puerto Rico, the island of enchantment. Yeah, we still are the island of enchantment. And it's with great patriotic love that we call it this way, although I recognize that the beauty of our islands is precisely one of the characteristics that all of our American territories share. Puerto Rico, U.S. Virgin Islands, American Samoa, Guam, and the Northern Mariana Islands. I appreciate the invitation because, as you know, I have only been a few months in front of the Puerto Rico Department of State, as acting secretary. Before that, I was the secretary of public safety, where I was actually working strongly in a joint effort with the United States territories in the areas of safety, crime, violence, and drug trafficking. This was a highlight, I would say, of my trajectory that through a military career that spans through 3 decades. The opportunity to serve in both the military and the federal government led me to understand a reality that's rarely spoken about. And I want to clarify, I'm not a politician, I'm not elected, but I'm an observer of our reality as resident of the United States territory. And when I witness the work the territories have to carry out in the search for justice in such areas of health, safety, and employment, no impartial human being can say that we are equal with respect to American citizens residing in the continental United States. Territories always have to work twice as much or even more to gain access to benefits, although when it comes to serving the nation from various areas, including the military, we sweat, we bleed, and we sacrifice ourselves in the same way. I serve in combat zones and in war, shoulder to shoulder with American citizens of all jurisdictions. I never saw an equal from an unincorporated territory as a lesser person. I never saw one with lesser pride on that American flag than the most proudful one from the New York State or any other state. Although in his return he had more and better health condition than the territories. Again, I'm not a politician, but I'm not blind either. That inequality has a name, and it's called the territorial clause. Among the territories themselves, there is a diversity of opinions on how they are visualized in their relationship with the United States. But I confess, for me, as a fellow American citizen, not having the right to vote in the national elections, no matter of location, is a case of our unfinished business of American democracy. The battle to be included in the federal programs such as Medicare and Medicaid, in which the continental states receive fixed formulas without a fight and which are taken for granted, hurts of all, and it hurts me. Having a voice with no vote in the Congress that formulates public policy and a way of life, it hurt us all, and it hurts me. Having as president of a nation a commander-in-chief for whom I could not vote, it hurts us all, and it hurts me. Being geographically discriminated against for living in a territory and not in a continental state, it hurts of all of us, and it makes me wanting to fight even harder. But that is me, and that is why I'm happy to be here, because this forum is about much more. Our economic and social development, human rights, history, and even promesa. And I'm very excited about the discussion. I invite you, in addition to seeing our differences, to explore the similarities that often do not derive from the political relationship. When you look at our history, you will find the greatest human value, solidarity. When I believe that this solidarity is enhanced by our territorial condition, I am convinced that its origin is empathy. We do not always agree on the ways, but we rarely fight our brothers. The American territories have a historical denominator. We have always been someone else. Might the fullness of our rights not rely on our partner, but on the firm belief in equality and a universal principle, in the end, being citizens of a great nation, that of the United States of America and of the world. Enjoy Puerto Rico. Blessings and Godspeed. Thank you.
Thank you to Puerto Rico's Secretary of State, Honorable Elmer Roman. Now we move on to, in the agenda, to have our next guest speaker. She's in representation of U.S. Congressman Raul Grijalva. She's engineer Margarita Varela-Rosa. She's part of the professional staff for the Office of Insular Affairs and also the Committee of Natural Resources of the U.S. House of Representatives. Please welcome Margarita Valera.
Buenos días. Good morning. On behalf of Congressman Raul Grijalva, Chair of the House Committee on Natural Resources, thank you for the opportunity to speak about the role the committee plays in advancing federal legislation that addresses the needs of the residents of the United States territories and freely associated states. Chair Grijalva regrets that he couldn't be here today because he strongly supports creating coalitions to advance progressive initiatives. He has asked me to pass along his thanks and his congratulations to the staff of the Jesus Piñero Library and Social Research Center for bringing together academics, legal experts, and delegates to Congress who share our goal of significantly improving the quality of life of the residents of the U.S. affiliated insular areas. Congressman Grijalva's tenure as chair of the House Committee on Natural Resources began in January 2019. That same year, I joined the committee's Office of Insular Affairs team, where I serve as a policy advisor to the chair. Today, I will discuss the jurisdiction and structure of the committee and outline Chair Grijalva's approach to advancing federal legislation. I will also discuss his legislative priorities for the territories and freely associated states, including PROMESA and the political status of Puerto Rico for the 116th Congress, which ends in December of this year. Under the rules of the House of Representatives, the Committee on Natural Resources has legislative jurisdiction over the insular areas of the United States, except matters affecting the revenue and appropriations of federal funds. Our mandate includes jurisdiction related to matters affecting the territories of American Samoa, the Commonwealth of the Northern Mariana Islands, Guam, Puerto Rico, and the U.S. Virgin Islands, as well as the freely associated states of Micronesia, the Republic of the Marshall Islands, and the Republic of Palau, under the Compacts of Free Association. The Committee's Office of Insular Affairs oversees legislation for U.S. affiliated insular areas. The office is directed by Congressman Gregorio Sablan, delegate from the Commonwealth of the Northern Mariana Islands, and Vice Chair for Insular Issues at the committee. Chair Grijalva is the point of contact for Puerto Rico-related matters, and he has serious concerns with PROMESA's austerity measures and the slow federal response to natural disasters on the island. Chair Grijalva's political trajectory and leadership style significantly influence his approach to advancing legislation. Before joining Congress, Chair Grijalva was a community leader in Tucson, Arizona, serving on both a local school board and on the Pima County Board of Supervisors. In Congress, he served for several terms as co-chair of the Congressional Progressive Caucus. His approach to politics is based on engaging with communities, not just boardrooms. For decades, Chair Grijalva has fought for economic justice, protected civil rights, promoted global peace, and advanced environmental protection and U.S. energy independence. In his role as chair of the House Committee on Natural Resources, he listens directly to people and communities and favors a bottom-up approach, not a prescriptive approach, in shaping agenda and legislative strategy. The doors of his office are open not just to elected officials, but also to community leaders and activists. His staff and his entire team share this approach. The committee and the Office of Insular Affairs have set a bold agenda for the 116th Congress. In 2019, Chair Grijalva, with the support of the delegates of the Commonwealth of the Northern Mariana Islands, Guam, Puerto Rico, and the U.S. Virgin Islands, introduced a historic bipartisan resolution rejecting the insular cases. The resolution, endorsed by the ACLU and NAACP, explicitly acknowledges that the Supreme Court's decisions in these cases rest on racist assumptions and result in discriminatory federal policies. It recognizes the importance of supporting equal rights and upholding the interests of Americans living in the United States territories. Last year, the chair, delegates to Congress, and other members of the committee prioritized the appropriation of additional Medicaid funds for the territories. A legislative solution was possible, in large part because the delegates, Democrats and Republicans, joined forces to guarantee basic medical services to vulnerable communities. This happened because of the broad national and local consensus that this policy was essential to stabilize the fiscal situation of the territories. The House Committee on Natural Resources held a hearing with local government officials from all the territories to encourage other committees of jurisdiction to prioritize this issue. As some of you know, President Trump intervened to cut the Senate and House funding agreement from 4 years to 2 years. We opposed this cut. However, the committee and the Office of Insular Affairs are satisfied with the federal matching rate increase, which reduces the fiscal burden on territories and allows them to utilize local revenues collected for other policy priorities. The committee has advanced and continues to advance other legislation related to the territories, including the Northern Mariana Islands Long-Term Legal Residence Relief Act, which grants resident status to certain immigrants who have resided continuously and lawfully in the CNMI to work on the island, and the Guam World War II Loyal Recognition Act, which modifies the use of funds deposited in the Guam World War II Claims Fund, used to pay claims of victims and survivors of the war. Most of our priorities for the remainder of the 116th Congress address issues that affect all the territories and represent opportunities for further collaboration, including climate change and economic development. All the insular areas are at the front lines of climate change. The Commonwealth of the Northern Mariana Islands, Puerto Rico, and the U.S. Virgin Islands have recently been impacted by severe storms that have cost too many lives and exposed the vulnerability of their infrastructure. The committee is already advancing and is fully committed to enacting legislative proposals to address climate change, which threatens the existence of many island communities. Similarly, the territories face serious economic development and fiscal challenges. This year, the Committee's Office of Insular Affairs will be applying its lessons learned advancing Medicaid legislation to other programs, such as the Earned Income Tax Credit, Child Tax Credit, and Social Security income. Recently, the House of Representatives passed key legislation that would provide tax relief through the EITC and CTC programs to all the territories. Studies show that these programs increase labor participation and reduce child poverty. We're now waiting for the Senate to assume its responsibility and move forward with this legislation. At the same time, the Committee on Natural Resources is committed to continue bringing together key stakeholders, elected leaders, economists, and policy experts to evaluate their economic development proposals. The Committee's Office of Insular Affairs in collaboration with the House Committee on Foreign Affairs and the Departments of Defense, State, and Interior, is also overseeing the negotiation of new compacts of free association with the freely associated states of Micronesia, the Republic of the Marshall Islands, and the Republic of Palau. These agreements are set to expire in 2023, which provides the United States an opportunity to strengthen its alliances in the Pacific region. Chair Grijalva's immediate priorities for Puerto Rico include improving disaster recovery, revising PROMESA, and addressing the island's political status. In 2019, the Chair visited Puerto Rico twice to learn directly about the devastation caused by Hurricane Maria and the impact of PROMESA's austerity measures on vulnerable communities. Also, earlier this year, committee staff, including myself, visited several municipalities impacted by the recent earthquakes. Since the beginning of 2019, Chair Grijalva has pressured the Trump administration to disburse federal disaster aid already appropriated by Congress to rebuild homes and the electric grid and to invest in resilient infrastructure. Last month, the committee published a report describing the damage caused by the earthquakes in the South to urge the appropriation of new emergency funds, which the House passed in February. As most of you know, the Chair has expressed grave concerns with the implementation of PROMESA, especially with austerity measures that have resulted in considerable budget cuts to essential public services and with insufficient debt restructuring agreements. In October 2019, the committee held 2 hearings to obtain feedback on a series of proposals to amend PROMESA, which include protecting essential public services, auditing Puerto Rico's public debt, and authorizing a mechanism for the territories to discharge unsecured public debt. The committee's Office of Insular Affairs has evaluated the recommendations, and we're very close to finalizing a proposal for the Chair that will include provisions that have broad support from national and local organizations because they would protect pensioners, students, and those who need it most. Recognizing that PROMESA is the result of Puerto Rico's subordinate relationship with the United States, Chair Grijalva is committed to initiating a conversation in the Committee on Natural Resources with other members of Congress about Puerto Rico's political status. The Chair has instructed the committee's Office of Insular Affairs staff to develop a proposal to begin this process. Having heard from local voices that support different alternatives for Puerto Rico's self-determination, one of his top priorities is ensuring that all non-territorial alternatives, statehood, free association, and independence, are given a fair hearing. We anticipate this process will include elected officials, historians, and legal experts. This process will start immediately after the Chair announces our final proposal to amend PROMESA. On behalf of Chair Grijalva, thank you again for the opportunity to speak today. As I said before, the doors of the committee and the Office of Insular Affairs are open to everyone, and we look forward to collaborating with you in the initiatives that I described today. We recognize that we have a lot of important work to do, and we look forward to it. Muchas gracias a todos.
Thank you to Margarita Varela. I was just telling her that I had met her before in Washington, D.C., October 2018. She was the founder and organizer of the Puerto Rico Diaspora Summit back then that gathered people from different organizations from civil society, from Imagina Puerto Rico, Boricuas Unidos en la Diáspora, Boricua Actívate, and some others, and they were trying to join forces to advance Puerto Rico agenda, the Puerto Rican agenda in Washington, D.C. It was a very, very exciting experience indeed. Now we go to the second panel. This one, for this event, the 5 U.S. delegates of the U.S. overseas territories were invited. 3 of them confirmed their attendance from the beginning: Puerto Rico, U.S. Virgin Islands, and Guam. Unfortunately, the U.S. Virgin Islands delegate in the U.S. Congress was not able to join us due to unforeseen events at the last minute. However, she sent us a video message, and we are ready to take a look at it if we have it available.
Good day. I'd like to begin by thanking the Jesus D. Pinheiro Library and Social Research Center for hosting this, the first roundtable of the United States unincorporated territories, and acknowledging my fellow territorial delegates and resident commissioner and other members of Congress here today. It is with sincere regret that I could not be with you all in person. The Virgin Islands knows a little something about tough relationships with their sovereign nation. From Denmark and now the United States, we've always had to fight for better treatment, and we know what it is to be neglected. Over 2 years ago, devastation from unprecedented major disasters altered our direction and legislative priorities. Since the start of the 116th Congress, I have been committed to increasing the economic outlook of the territories by focusing on efforts that help us rebuild, rebound, and regrow. The early morning hours of February 9, 2018, marked a significant step towards our rebuilding. Congress enacted the Bipartisan Budget Act of 2018, BBA 2018, which included critical disaster relief for the Virgin Islands. This assistance, however, was not anywhere near the full amount needed by the Virgin Islands. Included in the bill was crucial cost-saving resiliency provisions allowing the Virgin Islands, along with Puerto Rico, to rebuild critical infrastructure with increased resiliency. This provision was crucial as the region is on the front lines of climate change. Building resilient infrastructure is an economic protective measure. It's nonsensical for the federal government to pay to rebuild communities to a standard unlikely to withstand a future disaster. Yet clear or unavailable guidance from FEMA, cost-sharing issues, delays in dispersing congressionally appropriated federal aid, and disparities in federal law impede efforts for a full and resilient recovery. The proverbial cherry on top is FEMA's refusal to exercise its statutory discretion, which allows for the waiving of local cost-sharing requirements for various post-disaster activities. Despite it all, we continue to work alongside our federal partners to address these and other related issues. We don't want handouts. We want the tools needed for us to do the work. I have long advocated for many pieces of legislation to extend to the Virgin Islands as a tool to strengthen our economy. It's my firm belief that the Virgin Islands must create a diversified economy to become stable, grow, and ultimately improve quality of life for Virgin Islanders. Unfortunately, the 2017 Tax Cuts and Jobs Act have made investment in the territory less desirable, resulting in an estimated annual loss of hundreds of millions of dollars in tax revenue. To combat this, I proposed the Territorial Tax Parity Act, which would assist in reversing these adverse effects. The disheartening reality is that even under normal circumstances, the federal government underfunds the territories. Then, when disaster strikes, the federal government asks why aren't the territories responsible, and why aren't they as self-reliant as the states? This is fundamentally unfair and illogical. But unfair is what U.S. territories live with, from inequitable funding, lack of full congressional representation, and possibly the most egregiously, the denial of the most American of experiences, voting for our nation's leader. This leads us to be impacted by policies that never consider us. Long before we needed rebuilding, we needed infrastructure investment and increased economic growth. Now, as we continue executing our long-term recovery, we must do so cognizant of other long-standing financial issues. While strides have been made, territories continue to confront the difficult reality that our islands and the U.S. citizens who live on them have been neglected and allowed to fall behind. Until our voices are listened to and our voices counted, we are Americans without the full American experience.
So now we are going to have the opportunity in our second panel to meet current and former U.S. Congress delegates for the territories. Our guest panelists are Honorable Jennifer Gonzalez, Puerto Rico's U.S. Congresswoman as Resident Commissioner, who will be joining us at any time, and Honorable Michael San Nicolas, Guam's delegate in the U.S. Congress. On the second part of the panel, two other guests will also join: Antonio Tito Colorado, a former resident commissioner for Puerto Rico in U.S. Congress, and Dr. Robert Underwood will be with us again as a former delegate in the U.S. Congress for Guam. The moderator for this table will be Jose Delgado, journalist, correspondent in Washington, D.C. for El Nuevo Dia newspaper. And let's welcome Jose and the panelists to the stage.
Well, thank you to the Library Jesús de Piñero. Es un honor estar aquí en la biblioteca. Thank you to Delegate Michael San Nicolas for being here. Delegate San Nicolas was elected November of 2018. Yes, I was saying that Delegate San Nicolas was elected in November of 2018. But before that, he was a state legislator for 3 terms. He's a member of Congress that sits in the Natural Resources Committee, that is the one that have jurisdiction in the territories, as Margarita Varela was explaining, and the Financial Services Committee. Let's start before grabbing the bullhorns. How do you describe the state of relations between your territory and the government of the United States?
How do I describe that?
The relation, the current relation between the territory and the United States.
Well, I mean, all territories, I think we suffer the same consequence in terms of us having a less than equal relationship when compared to the United States at large. But I think that it's important, at least for me, to share what my perspective is in terms of why the relationship is the way it is and what we need to do in order to improve that. I think that there's a general idea, and I'm not quite sure if it's been born over all the history of grievances that was shared with us today, but there's a general idea that for some reason the United States is insistent upon our relationship remaining this way as unincorporated territories. And my experience, at least with the real life members of Congress, is that that is not necessarily the case. I think that our relationship that we have today is a result of historical circumstances that have manifested into this relationship that we have now. But I do not believe that there is an underlying intent among any of the members of Congress to actually keep this relationship the way it is. I think that we're dealing with very human members of Congress who need to be engaged in very meaningful ways that are able to make them understand the circumstances that we're in. And if we're able to engage them effectively in that way, we can bring about the change that we're all talking about here today. And so, yes, historically, our relationship with the United States is one of an unincorporated territory, lesser participants than full states, absolutely. But the future of our relationship, I think, is something that we can take control of, and we can definitely determine if we're able to meet the requirements to do that.
And how has been the relationship specifically with the administration? You know, as you were known, Puerto Rico has had some difficult relationship with President Trump. How is in the case of Guam?
I think that the administration, in particular President Trump's administration, is unique to President Trump, but I don't think that it's a representation necessarily of how the executive branch of the United States of America regards territories in general. I think that the relationship that all of our territories are experiencing under this current president is unique to this president, and I think that that relationship would definitely change under a different president.
Okay. Let's talk about status. At what stage is the debate in Guam about the political future of your territory? Jeff Farrow was mentioning that there were 2 referendums in the 1980s, and the Guamanians supported the type of Commonwealth. What had happened during the last almost 40 years?
That's a very, very important question. And I think that's a kind of question that not only is important for us to realize as Guamanians as we evaluate the future of self-determination on our island, but it's also a question that we need to evaluate as territories with respect to what it is that we want to achieve going forward. My grandfather was actually a former speaker of the Guam legislature, and he was one of the leaders of the movement for Commonwealth back in the 80s. His father was one of the first legislators in the Guam local government. And so I have a long legacy of grandfathers and great-grandfathers having served. And one of the things that I learned in my grandfather's service is that it's one thing for us to champion a cause. It's something else entirely for us to truly strive to achieve it. And so when Guam pursued Commonwealth back in the 80s, we did so trying to champion what it was that we wanted to extract out of the relationship with the United States. And championing those things is important because we definitely want to make sure that we're responding to the unique needs that we have, and we're responding to our constituencies and their expectations. But we need to be pragmatic if we're going to truly achieve what it is that we're working towards. And so the Commonwealth movement back in the 80s failed because the causes that were being championed were not able to be achieved. What happened afterwards was even more tragic. Instead of coming to the realization that achievement required us to take a more pragmatic approach, instead we doubled down on the championing aspect. We looked even deeper into the historical grievances, and we dug our heels in on what we felt were the wrongs that we endured, and we tried to, over the next 30 years, take a course to address those issues rather than take us on a course to actually achieve the outcome